Please be seated, everybody. Let's get the webinar started. Okay. This is case number 2018 CA 5321. Let's go ahead and take appearances, starting with the plaintiff.
Greg Anderson, Nick Whitney on behalf of the plaintiff.
And Tom Elegant, I'm Zoom your webinar, Your Honor.
Chris Altenberg and David Hughes on behalf of John Hopkins Children's Hospital.
Okay. Well, did you all have a desire as to how you wanted to proceed this morning?
Probably what we would like the court to hear is, well, I think we can first take up the argument on the proposed jury instruction, which I believe they've been printed out for the court now. Hopefully will be in one moment, our version of it.
My assistant's in meetings, so whenever she's out, she'll get to it. But we can't use my judicial assistant as your assistant
All right, well,
because she's got other responsibilities as well.
We're prepared to share it via Zoom video link. One of our associates should be joining as well for that purpose.
Again, as we indicated, you needed a participant link, which my judicial assistant asked yesterday. So can someone give me what you want to look at?
yes, it's very short, Judge, but the problem is it's electronic. And so if there is some place I can email it very quickly, you can have it in 2 seconds.
Well, the problem again is my assistant is doing other things right this second.
I can read it into the record.
Yeah, Your Honor.
Well, let's do with something else while my assistant is doing other things.
Your own outline suggested maybe the motion in limine I presented about the 2015 issue and Chapter 39, and the instruction he has, although it says it's false imprisonment, is really relates to the 39 matter. I suspect that those two things might. The first one probably doesn't take much time, but we could do those two, and then there's about 4 things in the jury instructions that if we know are disputed, and if we can resolve those, I suspect that Mr. Elegant and I can make a lot more progress on.
Well,
creating
then
the jury
let's do DIN 3411, docket identification number 3411, defendant J. Hatch's motion in limine to prevent evidence and argument concerning a claim for failure to diagnose and treat CRPS in 2015. Mr. Altenburn, your
Yes.
motion.
On that particular claim, the all of a sudden I dropped that file, but we have moved in limine because of the opening argument. The opening argument begins and talks a great deal about medical treatment between 2015 and October 2016. I don't have any problem or concern with that. The situation was an evolving situation that clearly comes in, and conceivably what is in Johns Hopkins All Children's Hospital's medical records on October of 2016 would inform some of the decisions they would make in that time period. But in the opening, it began to feel like he was saying that we should have diagnosed CRPS earlier than we did in that time period, that there was an opportunity to do that we missed, which has never been alleged. And then towards the end of his opening, there was discussion that because there is a theory that CRPS can be cured if it's treated early on, that we could be responsible, that Johns Hopkins could be responsible for all of the damages here because anything that Dr. that the other two doctors did after that point in time would be after the fact of this defendant's negligence as medical professionals. And that's never been alleged, as I've laid out in the motion, not from the first complaint till now. B, they alleged in the last complaint, and maybe the one before that CRPS is a permanent reoccurring disease, not that it's something that could have been cured at some earlier point in time. And finally, had they raised claims about errors in medical standards for 2015 in their original complaint in 2018, the first thing they would have gotten would have been a motion either to dismiss or motion for summary judgment on statute of limitations, because they knew from their own doctors that they had gone to that they believed that ketamine was the solution to this problem. It was the miracle, and they knew that well before 2 years from not only the filing of the complaint, but from when they made their first notice letter. So I'm not asking that evidence not come in. I'm asking that there not be a jury instruction on a standard of care or a theory about a medical negligence claim prior to entry into the hospital as explained in the complaint in October of 2016, and the arguments that we should be responsible for all the damages because our negligence occurred before their doctors ever saw that the patient also should be excluded.
Is it Mr. Elliott or Mr. Anderson? Who's going to make this argument?
Yeah. I think this one's mine, isn't it? Your Honor, Tom Elliott again for the reporter. We filed a response, which is DIN 3423, I believe. And this is the plaintiffs are not making a claim for medical malpractice based on 2015. This is, as we say in the response, this is background information. Both sides referred to it. We cite a number of places where the defense referred to what happened before that. So I don't think that we're not going to ask for a line item verdict on 2015. I mean, this is not the instructions in front of you now, but they're in the med mal instruction. If the defense is still planning to blame the earlier doctors, we're going to have a discussion about the level of proof for that. I think it's not clear to us at this point if they're still planning to do that.
Well,
but that would also, of course.
Let me ask you this. What am I supposed to do with Mr. Anderson's comments in opening statement that Johns Hopkins All Children's Hospital missed 7 prior opportunities to diagnose CRPS?
Your Honor, I think that's relevant to how they handled it when she got there. Having missed it, the jury would be entitled to wonder, to infer from that, well, maybe that's why they wanted to say it wasn't.
Where is that covered in the pleadings? Where is that in the Eighth Amendment complaint? Can you point to me any paragraph in the Eighth Amendment complaint?
It's a long complaint. I'd have to dig in, Your Honor, but I think, in the medical malpractice claim, let's look at that.
Beginning, if I may, Your Honor, paragraph 19 under background, which is realleged and reaverred of the Eighth Amendment complaint, and follows through with the treatment regimens.
And then 127.
27 as well.
I mean, it is, as I think Mr. Oldenburg said, part of the story. That doesn't mean it's the plaintiffs are seeking monetary relief for that, but it may explain, in their view, something the jury can consider what happened, or some of the reasons for things happening later.
Hold on a second. 127 isn't backwards looking. It talks about terminating Maya's CRPS treatments the October 7th. And then, was it 17 you said?
And
19, Your Honor.
19.
Is the
which is going to be incorporated right into, that's incorporated into the medical malpractice count.
Right, but nothing about 19 suggests any sort of culpability on the hospital's part concerning events occurring in 2015. The point is that, and as I'm sitting here, I thought Mr. Anderson was trying to allege that we're trying some issue involving 2015 when clearly we're not.
Judge, my point of view, from our point of view, and the reason we put that in is the jury had to know the number of opportunities that they had to develop the information such that in 2016, she was again seen on multiple occasions, and we allege, and so if they knew back then and put it into the records, when she came back in, we're not alleging that they should have identified it immediately. Nobody did.
I think you said they missed the opportunity to diagnose CRPS 7 times.
Well, that's true, and most of those fall in 2016. Now, we're not alleging that in 2015 that they malpracticed by coming in, but I don't think an instruction or any type of motion in limine is warranted for background information. I don't really understand what their motion is. If it shouldn't be, based on the court's prior comments, it shouldn't be to exclude the entire lead up to what happened in 2016.
I don't think that's what Mr. Altenburn is saying. It's your pointed comments gave the impression to this jury that we're trying something that's not contained in the pleadings. And he doesn't want that to happen. I don't want that to happen.
So if the ruling is I am not to address, and my experts are not addressing, so the court knows, my experts are not addressing any culpability for 2015. We're not. And I do not intend to raise any further other than to point out they received information and symptoms throughout 2015 such that by the time they were approaching the October date, they had every bit of information they needed to come in, including diagnoses of CRPS, which I think is part of one of their claims is that, we did spot it. It was just one of our many that we thought. So having the statement that they missed these opportunities does not mean at the time. It means that they had the information all along. Now, if the court wants an assurance from me that in closing or with my experts that I'm not arguing malpractice in 2015, you have that. What I am arguing is that when she started to have a relapse, when she began coming back in 2016, they were armed with every bit of evidence necessary so that none of this should have ever happened. And that is clearly alleged in the complaint. And that has clearly been testified to over and over again by Dr. Neuberger, among others, including Dr. Kirkpatrick and Dr. Chopra. So I'm not sure what the defense wants. Motions in limine are not to be used as summary judgments, and they're not to be, usually you don't hear about them in the middle of trial. I do not want I pray the court that we don't have any instruction that might diminish my standing with the jury on that point. If there needs to be an order that says the plaintiffs are not going further to make any allegations or statements from which the jury may infer prior misconduct in 2015, not misconduct, but medical negligence in 2015, then I'm not opposed to that because that's not a big part of my case. But I just simply want to make sure that I can reference the history of treatment because that is absolutely pertinent to the decisions they made in October of 2016.
Mr. Altenberg.
Yes, Your Honor. And it seems like we're not very far apart on this at this point in time. So, if he's giving us his assurance, he's not really going to try that. I as an officer of the court, I will trust that. But I do think, as you point out, that I was left with the impression, it seems like you were, I'm afraid the jury was, that we were trying a case beginning in 2015, and a curative instruction that doesn't need to be a long instruction that simply explains to the jury that the medical malpractice claim is a claim for decisions or treatment made in October and thereafter, informed by what John Hopkins knew from their own records in the past as well. I don't have, we can work on the language of that, but I don't have problems with that, because I agree, if whatever was not in the universe but was in the John Hopkins records on October 7th, 8th, and 9th is material that they probably had access to and could look at. He can argue that part.
Well, if I may, Your Honor, we believe that this is something that can be handled through the instructions at the end to make very clear. We have no doubt in the ability of the defense to use that instruction to make clear to the jury that this case is about what happened in 2016, not about what happened in 2015. Hopefully the instruction would say, you may consider the information carried forward, or words to that effect, but that's something to be decided down the road. Right now, we object to any order in limine or instruction to the court. I understand and have put on the record that neither me nor my experts are going to raise or testify to medical malpractice that is a breach of the duty of reasonable care, a deviation from the accepted standard of care during 2015. However, they are going to testify, as they must to lay the appropriate predicate, about the course of dealings and the course of treatment from the first that they got with Maya. They were treating her, in fact, before she ever came down with CRPS, or however you phrase it. They treated her in June of 2015. So that's all background. But we're not going to bring in an expert that says they began malpracticing this case in July, was the first treatment, 7th of 2015.
Well,
October.
No.
Well, because Mr. Anderson has made clear he is not trying that case, meaning a medical malpractice case from 2015, we'll go ahead and take Mr. Anderson at his word for that. Certainly, I don't think Mr. Altenburn was seeking to preclude information about what happened in the lead up. I think that certainly is fair game and relevant to where where these pleadings are. But I do not want there to be claims argued that are outside the pleadings. We've spent a lot of time trying to identify what is and is not being tried. As far as any type of curative at this time, I'm not sure, Mr. Altenburn, I need to do anything. I'll think about it, but I tend to think that when I am instructing the jury as to the specific claims, if necessary, we can put time frames in there. I think that if we need to do anything, we can probably handle it that way.
And for the record, I'm going to leave that to your discretion. I'm not going to object if that's the way you do it.
I think that's probably where I'm going with it right now, so we'll leave it. So what's next?
I think counsel wants to talk about the jury instructions. What we have next is, and it's or a tennis, and I can submit in writing, but we needed a clarification on the testimony of Dr. Kirkpatrick and Dr. Richards based on the court's order of, now where's the back page of the order? Order in limine, I believe.
Did you tell the defense that you were going to be doing this?
I have not filed anything in writing.
I don't even know what he's talking about, to be honest.
I'll file something in writing.
Well, the issue is I don't know if this is a Mr. Hunter or Miss Crowells or Mr. Shapiro. I mean, you have Mr. Hughes here and you have Mr. Altenburn, but if it's dealing with something that one of the other lawyers is dealing with, then unless you've told them that you're going to do it, then I'm not sure we should be hearing it right now.
Yes, sir. And for the record, this is the court's, we'll be moving for rehearing on the court's September 22 2023. And it's really, it'll be rehearing or more appropriately for clarification. I want to establish the bounds within which Dr. Richards can testify concerning causation, and also Dr. Brewerton's ability to testify concerning the standard of care for the psychologists and psychiatrists at Johns Hopkins that were involved.
Okay, well, you first started talking about Kirkpatrick, then you changed
I'm
it
sorry,
to Richardson's.
No, that's my mistake. There's too many doctors in this, Judge. Brewerton and Richards.
So that's DIN 3410. I'll follow your motion. And when do you anticipate those doctors testifying?
Not until later on next week, maybe midweek.
So let's get your motion filed, and we'll carve out time to address it.
Very good. I just wanted to avoid bringing somebody in or asking the wrong question.
What's next?
I would suggest we try to resolve whether to give something on Chapter 39 as soon as tomorrow morning.
Okay. Is there language, and I think you gave me something
I have
Friday, and
I gave you something Friday, and there's actually a paragraph from what I did earlier that might also be an alternative. I'm happy to kind of read them aloud to you as well if you want me to.
because it's sitting in my office at home on that particular piece of paper.
Is this 3420? Docket index number 3420?
It probably is, Your Honor. I don't know that I've got that piece of paper right in front of me at the moment.
It looks like it was filed 9/25.
This looks like a 2-paragraph, but what you gave me the other day was a 3-paragraph.
Initially, I gave you one in writing, Your Honor, and I realized I wanted it in the record. So Mr. Ellicott's correct. I went ahead and filed it, and when I did that, I just did the 2-paragraph version of that.
Well,
Is what I did.
this is referenced to DIN 3420 for the clerk. And what's written in 3420, Mr. Altman, looks like your first 2 paragraphs and not the 3rd paragraph.
They're very, very close, maybe a word or two off, but basically it says, during opening instructions, I told you that Johns Hopkins All Children's Hospital reported suspected abuse to the Department of Children and Families in good faith, and that the hospital cannot be found liable in this case for having made that report. After that report was made, the Department of Children and Families filed an action against Jack and Beata Kowalski. In that action, the department obtained a court order on October 13 at 2:30 a.m., allowing the department to take custody of Maya Kowalski, subject to the court's jurisdiction. Johns Hopkins All Children's Hospital did not take Maya Kowalski away from her parents. It is not liable for the court's decision to enter this order. And if you wanted to, it could go on, enter this order allowing DCF to take custody of Maya Kowalski. Now, I would point out, by the way, in the one I argued earlier, I had asked for the sentence, Johns Hopkins All Children's Hospital cannot be found legally liable for making the abuse report for the department's investigation of that report, the filing of the department's lawsuit, or the entry of the shelter order on October 14th. The claims in this case do not include claims for those matters. And I had taken that original language essentially out of the partial summary judgment order that you had granted in part concerning the parent agency of Sally Smith. So that language might still be preferable to me because we've already gotten in, well, for example, yesterday, Dr. Duncan talked about getting a big disk of medical records from DCF. Well, she got part of their investigation. The fact that these things are going is beginning to come to this jury. I feel like the jury is probably a little bit lost and confused yet about what the story, how to put the pieces of this puzzle together. And so in some ways, I would prefer to have all 3 of those taken care of now. But if the court only wants to go as far as the taking away issue, the one that I presented in the filing a couple days ago.
Why don't we do this? Why don't you put your language on here? It's not going to help Mr. Elegant, but it's going to at least be able to help Mr. Anderson and me. If you just go up to the document projection, see if I can figure out how to do that.
I do have 3420, Your Honor, so I have the first two paragraphs here.
You want me to come up here, Your Honor?
Yeah, I'm just trying to figure out how to turn that on from here. I think there's a button you have to push.
My expertise with this is limited, so.
Let me.
The power is on, and power is on. Well, now it's on. Now it's on. Okay.
Your Honor, when you're ready, I do have some comments on this.
Yeah, I'm just trying to get the document camera going. Mr. Hughes, is there a power button?
You pressed it, it was red, and then you pressed
Now it's
it.
blue,
Blue.
and there's a
Mine's on.
there's a blue showing this device being on.
Mike, can you help us get this Elmo? I've got it on
I got it.
lectern right.
It's up on ours. You need to turn it the other way, though. It's sideways on us. That's better.
Tell me where. Okay.
And you can focus it on the top there by twisting it.
Okay.
I have a lot of Elmo experience. There's a knob.
I
underneath
continue
there.
to have
Underneath
trouble
it's
getting the
knob.
gallery in.
You can make it there, other way.
Well, the gallery screen, so I usually have to turn it off and then turn it back on.
Yeah, I think we can work with that.
Let me just do this.
Oh, and it just went off.
Well, I did that on purpose because I'm trying to get the gallery ones open. Turned on. There we go. I don't know why it does that. Okay, thank you. Okay. And so, Mr. Elegant, we have the original version, what Mr. Altenburn put on, I guess, gave on Friday. So do you have that sheet of paper?
I think I do somewhere, but what I've been working from, I assumed that this 3420 was revised, and that was what we were going to be talking about. So I'm sure I can find the other one, but
I
mean,
What's on the screen may possibly be a couple words off what I filed, but I'm not positive.
They're pretty close, but what we'll do is we'll tell you what the difference is. But just as an overview, Mr. Elliott, what is your view of at least those first two paragraphs?
Well, Your Honor, we filed a response to the earlier version, and it is DIN 3424. And I mean, the first thing is we don't see why this is necessary to interject this as the plaintiff's case. I mean, simply saying somebody got records, for example, from DCF hasn't told the jury. I mean, you already told them. You already told the jury in the opening that John Hopkins is not responsible or is immune for the report. The jury, I'm sure, will hear over time that the report led to a custody order. But the problem with this I mean, paragraph 1 just repeats what you already said in somewhat different wording, the immunity. Paragraph 2 is, in our view, way too slanted toward the story that the hospital wants to tell. It leaves out your admonition in the opening instructions that the DCF proceedings do have nothing to do with the plaintiff's claims. In other words, the plaintiff has a claim for false imprisonment. Looking at this, I mean, it talks about, in that department obtained a court order allowing the department to take custody of Maya Kowalski subject to the court's jurisdiction. I mean, are we going to put in there they didn't have permission to do it between October 7th and October 13th. I mean, we have the instruction that the alternative or the addition that Mr. Anderson referred to earlier. It's very short. I could probably figure out how to share the screen here. I'm not sure if that would help for the people who are live, though.
Your Honor, can you inquire of the clerk whether she was able to make any copies, receive it? So it went into your JA. Okay.
The only thing my JA brought in a moment ago was plaintiff's proposed interim instruction on false imprisonment. That's it. 2 sentences long.
Yeah, that is it, Your Honor. It's labeled false imprisonment, but it really goes to, because it needs to be, the jury, and you've already told them this, but if we're going to start reiterating things, they need to be told, if they're being told again, basically that the hospital has immunity for DCF, they need to be told, and that immunity and the DCF has nothing to do with the plaintiff's claims. So that's what this was an attempt to do, to say, you're going to hear some facts, that's facts and circumstances, that some that are and some that aren't relevant in making your decisions. And talking about the shelter order, which is in paragraph 2, has no effect on the plaintiff's claims I instructed you at the beginning of the trial, and that I will instruct you at the end of the trial, including the claim for false imprisonment. I mean, we could go on and say, in the videotaping and the pictures and so forth, but if they're being told, the jury's being told, well, they were allowed to do this at certain points of time, they need to understand that the order did not immunize them from the plaintiff's claim that they were not allowed to do it at other times.
I mean, from a conceptual standpoint, what's the harm in telling the jury the specific date and time that the court entered the shelter order?
I can speak to that, if I may. That is that it misleads the jury into believing that one order somehow precludes a number of the, already testimony that has been made in court and will be made through the experts and through the additional witnesses and through Ms. Kowalski. And I'm concerned that there are 5 orders that we're talking about here. We've got orders from October 14th, the original shelter. We've got November 11th, November 12th, January 3rd, January 14th, April 20th, that all change the scope of the custody. Now, they don't release from custody until the 13th, actually, of January. But the concern is, if we start down this road about the effect of orders and only focus on one aspect of it, it will affect all of our causes of action, and especially our medical malpractice cause of action, because the jury, and the intentional infliction of emotional distress and negligent infliction of emotional distress, because the jury will be left throughout the remainder of the testimony, and they'll just, being jurors, they'll just turn off to a lot of the testimony, believing the impact of that order on the causes of action is much, much greater than it actually is. The court's already been down this road and has done a yeoman's job of going through all of this to find those parts that are not subject to immunity. To come back in and raise an oblique reference to an order is going to completely, it'll affect every aspect of our case. And so we submitted a very basic one if the court determines it's absolutely necessary for some reason. But all of these issues, first, the court made, we all came up with, and the court read an instruction at the start that was directed towards the first 2 calls being immune. We all understood that. I acknowledged that in my opening. And then I relied on the court's statements in coming up with these and the court's instruction in the manner in which I delivered my opening about what the story was and what they can consider and not consider. And so if we go in at this point, and I beg the court not to submit anything to the jury right now until you have heard more of our case, because there is a strong argument to be made here, Judge, if you'll just listen to some of our witnesses that are coming in. There's a strong argument to be made that none of this should have ever happened had Johns Hopkins diagnosed when they should have diagnosed and not diagnosed when they misdiagnosed. And so I beg the court's indulgence that if you do come up with something here, which we do not believe is appropriate, we think all of this can be taken care of at the end of the case, but if you are going to, please let us get through another week of testimony. I need to say at this point that Dr. Kirkpatrick called us late last night, and he's ill. So he's not going to be able to testify tomorrow afternoon. So we are strongly considering putting Maya Kowalski on if the court and counsel will again indulge us. She has some testimony. It is very difficult to get out of her. I know I'm off track here, but the point is I really, really need the court to hear more of this case before we consider focusing the jury on a particular point. From their point of view, the way I was thinking of it, reading this, is they're going to go, what's all this testimony about her not seeing her mom and dad and anything? So, you know, the judge just told us that's all out. That was the impression I got, and I think that this will have an impact on the jury far, far more than what any of us in this room are contemplating, and I'm very worried about it.
Well, let me go back to your first statement.
Yes, sir.
Of your speech there. How is it misleading to the jury to tell the jury the specific date and time of the shelter order? That I don't understand. How could that be misleading? I mean, I was somewhat perplexed when no one said it in opening, talking about the specific date and time. Now, perhaps that's because now you kind of changed how you're approaching this case and not talking about DCF. That's fine. But no one said it to the jury. And so what is wrong with telling the jury the specific date and time that the court took jurisdiction over Maya?
Because the term jurisdiction and the impact of a court order to your average citizen is overwhelming. And because the jury will then conclude that anything that happened after that date is really kind of irrelevant to everything. Because if the court ordered this, why are we listening to any of this stuff? And it will diminish the impact.
The court did order it.
The court,
and so we're not to talk about it now?
We're not to talk about it until we have a chance to put on our rebuttal, and so that this court and the jury can hear exactly what went on with the entry of those orders, and also so the jury can hear the testimony of my experts about how, and they won't, I don't know if they're going to mention the order specifically, but about the timing and the causation and the other theories of the case. That's all going to be, I am willing to wager you're going to get a lot of closed body language and looking up in the air and just kind of not taking notes and looking around as to any of the testimony that goes after that date. It presents to the jury a cutoff date where for the average person's mind, after that, well, the judge has got control. Who cares what happens?
But there are cutoff dates in the pleadings because of how you pled the case and how I've had to rule on the good faith reporting. So there are specific dates and times. And what you're suggesting is we disregard those dates and times, muddle everything together, and then not tell the jury what those dates and times are. I think that's very misleading to the jury.
All right.
So like I said the other day, we're going to do this. We're going to make a statement, and it's going to include dates and times.
Now,
so
with that,
that's why the other day I said, we're going to do this, come up with something, and your side ignored that. So that's fine. But understand that I said that, we're going to do it, and then you didn't do it.
we did submit something this morning, and let me explain also, Judge.
I don't see any date and times on this.
No, it needs dates and times. From our position, it didn't need to have dates and times. It simply had to make the point that at some point the court entered an order. But if I may, Your Honor, if it's the court's position that the jury should be informed of the date of the shelter order, then it should address solely the fact of the false imprisonment, and it should only address, and it should also mention, I will instruct you at the end, the portions of time you may consider for false imprisonment. That is the truth of the matter, is that this really only applies, this order that we're all contemplating here, which is the shelter order. Am I correct in this? And so if the court is of the opinion, and I understand where you're coming from, Judge. We don't want to mislead the jury in any way. That's not the plaintiff's point of view. But it has to be limited enough so the plaintiff has the opportunity to present their case without the jury concluding that, big deal. And there are multiple orders. And so if the thing gets broader than that, then we have to get into all of the timing, because every one of these orders change the different obligations and times and who could visit and not could visit and all of that, which I don't think is the court's purpose here. The court's purpose here is to let the jury know that a shelter order was entered at this time. I understand. But it should be limited to false imprisonment, and it should have something to say, I will at the end instruct you of those periods of time. Or tell them, Judge, these periods of time, there was no authority under the court's order. And that way, you can inform them and the plaintiffs won't be jeopardized.
I feel that we need to tell the jury the times to which the false imprisonment is allowable and false imprisonment is not allowable.
Thank you, Judge.
I think that is fair to the jury. I think it has fidelity to your pleadings and has what we've been talking about for the last 2 years. So
yes, sir.
I would like an instruction that has the dates and times specifically. Now, I get, and I've indicated this in prior orders, that there are times that Johns Hopkins Children's Hospital is potentially liable for false imprisonment. I agree that there are those time periods. Let's just tell the jury what they are. I don't think we can need to hide that.
Reserving on our position on whether one should be given at all, but the plaintiffs find that acceptable and would agree with the court in that type of wording.
Mr. Alden.
For the record, first of all, the reason I'm asking for the specific issues about taking away is that we've now had 3 lay witnesses who understandably don't understand the details of the law tell the jury that they or Johns Hopkins took Maya Kowalski away from the family. Linda Brown did that as the 3rd one yesterday afternoon. So the jury are adult learners, and you're correct, they need to get this in segments, and that's the segment right now they need to understand, is that we didn't take the child away. The court did that, and we're not liable for that. That said, while she was in the custody of DCF and under the jurisdiction of the court, she was in our hospital. So even though she was in our hospital, that didn't give us immunity if we locked her in a closet for 2 days. And what the 3 things they are alleging is that while she was in the custody of DCF, we didn't release her for a couple days in October. We put her in an EEG room for 44 hours sometime later, and that we put her in a room to take photographs of her for a couple hours in January. Those are the 3 events of false imprisonment. They don't have anything to do with the custody issue, and if down the road the jury, again, as adult learners, need another segment to explain that, I am totally fine with that. And as to the visitation issues, as I've watched the last couple of days, I realize it's not something that we can just give them a one soundbite to explain. And he's probably correct. There's 4 or 5 orders that probably the simplest thing is to put them into evidence, either in their entirety or redacted, because there's some judicial comments in them that maybe we don't want the jury to see. But one way or the other, we can deal with that too down the road. But right now, I'm not prepared to tell you what I think should be told to the jury about about visitation at the moment.
Well, I hear what you're saying, which is a little bit different than what Mr. Anderson and I were just talking about
Right.
on false imprisonment. Conceptually, I understand what you're saying. the concern is because of the dependency court and the different orders, the status did change at different times. And so,
Visitation status did.
correct.
change. Right. That's
And
correct.
so that might be another one where we've got to
If-
identify a specific date and times.
If you felt it appropriate to give even language tomorrow morning explaining that there are additional orders on visitation and I may discuss those with you further at a later time, I have no objection to that.
I believe that they are trying to put their case in our case through the court. And I further believe that if we simply introduce these orders, we're going to have a jury so confused they're going to be out for 3 weeks. And they're going to have a question a day. You just know it's coming when they try to interpret 4 orders, especially when the end one says, oops, sorry, all this was kind of by mistake. We didn't have enough evidence here. So what I would suggest, Judge, is that we get together, counsel, we do a timeline or figure out how these orders interact so we can come up with an instruction for the jury at the end of the case that says, now, in considering the plaintiff's claims of false imprisonment, here are the dates. In considering the plaintiff's claims of allowing visitors, here's what's allowable, or here's the parts that here's what the order said. I think that putting these in, and I understand the defense might be worried, well, are we waiving anything? And for the record, I'm not, I'm taking the position that they don't need to put these in to get the information in front of the jury, and I don't argue either that in any event, putting just the orders in and then having the various witnesses interpret the orders usurps the jurisdiction and the duty of the court. I'm not telling you your duty, but you already know. I didn't mean it that way, Judge, but you know what I mean. It gives the power of interpretation to the witnesses. That's not correct. How these orders interact with the evidence is up to this court. And so I would oppose putting the orders in, and I will stipulate in the record if the defense needs anything to protect them from not putting the orders in. But I think that's the best way to handle it according to the law.
Well, there's a couple of issues that I'm hearing right this second. One issue is Mr. Altenburn's issue that plaintiff's witnesses are coming in and said the hospital took the child, which legally is incorrect. The hospital didn't do that.
Well, if they did actually the first 24 hours.
And
Well,
first 7
that's a false imprisonment claim, which is allowed, but the physical sheltering of the child is not something that the hospital did. That's something the dependency judge found there to be probable cause for the sheltering of the child.
I understand, but again, I come back to the fact we're talking about the wording of, I think, 1 or 2 witnesses about taking the child. The simple facts are that before that order was ever entered, they had no basis for keeping that child, and therefore they took the child and kept her away. And this was the start of all of these proceedings. They did not gain jurisdiction by making that phone call. The hospital did not have jurisdiction. They did not have an order. They had no legal cause. They had no reason. Now they're going to argue, but they had no reason under the law to take Maya away from her parents to start with. If I understand the court's interest in saying a shelter order and parts of this thereafter are actionable and parts are not, I get it. But insofar as that wording is correct. And there's no need, in my view, to correct and take away and diminish from the fact that from the first part here, they didn't have squat for legal authority to take this child. They made that decision up, and if the court will allow, and that's why I'm hesitant to even, I'm begging the court to hear more of our case in this regard. But once the evidence comes in, I believe it's going to be very, very clear the reasons why and what they did to the child had nothing to do with whether they believed she had a victim of Munchausen by proxy or whatever it morphed into lately. And so I really think the court needs to hear more of that case, and if it needs to be set out the specific dates that are not actionable, fine. I still say that that's something for the end of the case, and I relied on that in my opening. So what I would propose right now is that we be given the opportunity to develop an order. Now we understand the court's position, but that we should not be obligated to backtrack on testimony that was technically true. It was true. They did not. They kept this child because they stated AMA, and we can prove, if I had my enlargement here, I'd prove that they specifically said a patient here can leave at any time. And that was in their rules, which we'll put into evidence, and that was in their protocols that we'll put into evidence. So they violated their very own internal rules by keeping that family their AMA. AMA, against medical advice, has no force of law, none. So they took Maya and took her away. What's wrong with the witnesses saying they took her? I don't think that's necessary, Your Honor.
Well, let me hear from Mr. Altenburn, and then I'm going to tell you where my thoughts are.
As to the period between the 7th of October and the entry of this order, I think there's going to be disputed facts about time periods and whether she could or couldn't leave the hospital. And so we do probably need to hear evidence on that. The testimony I've heard, especially like yesterday, was Beata called this woman and said they've taken it away. They're talking about the shelter order, not this earlier point in time. And so as to this earlier period, I'm sure that the evidence will be developed, but it wasn't that we, again, the issue of whether we took her away from the family is not something that is being accurately explained by the questions asked and answered by the witnesses in this court, and we needed an explanation of that. And so I believe that this is an accurate explanation of it.
This is where I think the testimony, I think there's enough testimony in now that it's important that we give the jury some context in how it should be evaluating the testimony that's coming in. Specifically, I do think we need to identify the periods of time associated with the false imprisonment claim. I also agree with Mr. Altenburn that the entry of the shelter order is not the hospital taking the child away. And I think that needs to get made clear to the jury. Because contrary to Mr. Anderson's argument, I don't want to have this perpetual testimony over and over and over again on an issue I know I'm already going to tell the jury that the entry of that shelter order is not taking the child away, is not the hospital taking the child away. I already know that. I know I'm going to say that. So I am fine doing it in one combined instruction if we want to break it out into multiple instructions. I do think, although I don't think we need it tomorrow, I'm not opposed for it tomorrow, but I do think at some point we're going to have to identify for the jury the changing nature of the dependency court's orders, and again on time frames. Now, one other corollary to that, which was referenced, and I agreed with Mr. Anderson the other day, and I still agree with him, is sometimes the order said X, and then there is either an interpretation by the hospital or a request to, I want to call it HRS, DCF now, to DCF. That isn't part of the court order. So I'm not, right. I don't think that portion should fall in my instruction relative right. to the nature of the dependency court's order.
And I
agree with Mr. Anderson on that.
And I think I'm not disagreeing to any great extent on that the order, shelter orders are a standard order, and the other orders I know that there's actually evidence that Ms. Beatty called to get explanation because two sentences seem to be inconsistent ones. So to some degree, it's going to depend upon, I'm assuming this is all coming in on intentional infliction of emotional distress, by the way. It's not an affirmative defense that I've got, but it's going to have to come in as, whether we, I don't know whether negligently is the right word, but whether we properly implemented these orders when we received them. And there certainly is going to be some disputed evidence on that issue.
And at the end of the day, I'm going to look to the lawyers if we're going to put the orders in, or it's going to be an instruction, or both. But I do trust the jury, so I am, when in doubt, I'm going to put the order in. If y'all are on a jump ball, and I'm probably going to put them in. Whether I do it with an instruction that kind of explains, I might do that.
And I provided that instruction earlier. They had all of them in it. It's a hard read. I'll put it that way. I don't know that I would want to read that to a jury if I was sitting where you were sitting.
Okay. So, given my statements, Mr. Elegant, hold on a second.
Sure.
Given my statements, do you, and I guess this is a Mr. Altenburn and Mr. Elegant question, take my statements and try to fashion something, or are we sitting here doing it by committee right this second in open court?
You want something like what we have now, but also has some explanation of the false imprisonment periods in it? Is that what you want?
I want to identify dates and times. I do not want to give an impression that the entry of the shelter order immunizes the hospital from conduct, because clearly that's not what is the court's intent.
Okay.
So, and I think that was where Mr. Anderson was going. He didn't want the instruction to have a judicial gloss that the jury would then disregard evidence.
Rather than trying to do that on the fly, if Mr. Elegant has time, I would think this afternoon he and I can get on Zoom together and probably get very close to what you want.
That works for me.
Okay. Thank you. Now, Mr. Elegant, was there something else you wanted to say on this issue?
No, Your Honor, I think you just covered it there, because you reiterated that we need something more than these two paragraphs. We need something that says, look, this doesn't affect the other claims. It doesn't affect the claims the court has found are viable to go forward for the jury to consider. So I think we need let's see if we can work out some language on that. And I'll talk with Mr. Anderson and Mr. Whitney before that, so we're all on the same page.
Okay. Let's change subjects for a second. And, Mr. Hughes, I don't know. I assume it's going to be, I don't know who's going to do the cross of Maya Kowalski, but are you telling us, Mr. Anderson, that Kirkpatrick's not happening tomorrow and we're having Maya Kowalski?
Let me tell you exactly what I know, again, as an officer of the court. We received a phone call. Dr. Kirkpatrick is vocal about when and how he wants to testify, but last night we received a phone call, which I was able to return this morning, in which he informed me that he has some kind of bug, as he put it. It actually sounded in the background like he did have digestive problems. Anyway, I take him at his word. So I asked him how long. He said he didn't think it would be good for him to come in anytime over the next couple of days. That leaves me with a big hole in my case. Maya Kowalski is a possibility to come in. Her testimony would be limited, and it would be limited to really the period that she was in the hospital and those events. And frankly, the reason, Judge, is that right now the jury has not gotten a big picture at all. They think this case is about a statue and not being able to pray. And so what we wanted to do was to put her in for a given period. The alternative is this. If the court says, no, it needs to all go at once, and we'll hold her out and we can play depositions and maybe find one live witness for the afternoon. We have Dr. Chopra. He may take it into the afternoon. So that's all I know.
Well, let me throw this out. And Mr. Hughes, I don't know if your other folks are listening in or if you've got the ability to convey a message to them, but
I can text.
I was going to talk about our schedule for next week. Friday afternoon, which I guess is October 6th, and I think that's one of the days that we previously talked about, which was a maybe. The afternoon, we're not going to be able to have court. We can do court in the morning. Because we seated a jury faster than I anticipated, I feel like we're ahead of our schedule right this second.
Right.
So I was going to suggest and get the lawyer's view about, if we take a half day on Friday, do you want to take a half day sometime else during that week? Or do you want to just take all of Friday off? Or do you want to leave at 4:00 on Monday through Thursday? Or now, if we've got an issue with Dr. Kirkpatrick, if your other doctor, and I forgot, who do you have else coming in?
Chopra is coming tomorrow from Boston.
In the morning?
Yeah, I hope. He's supposed to fly in this afternoon.
Okay, so assuming that he goes in the morning, do you want to take the afternoon off and then just not take a second half day next week? Or what are your thoughts as far as how to proceed?
Let me be frank, Judge. We have to fly in a lot of people. And because of that, and because schedules constantly change, we could use a day off now and then to prep and to get these people in so that this thing moves through efficiently and without a lot of wasted time with exhibits and so forth. So taking off at 4:00 on the days we're here doesn't help the plaintiff that much in terms of, because frankly, I'm pretty burnt by the end of one of these days. It's hard to stay up late and adequately prepare witnesses. So I could use a day off about every week. I believe that we're way ahead of the schedule, and that's all I'll say.
I'm certain we would rather have all day on Friday than to have bits and pieces as well.
Yeah, but if we do all day Friday, then that means effectively we've got Thursday, Friday, Monday, Tuesday, Wednesday, Thursday without a break.
That's right.
We prefer a half a day on Friday and a day sometime next week. Actually, when we first started talking about this, before it morphed into 8 weeks, the court was contemplating taking Fridays off. I don't know that we need to do that. I don't know that we're that far ahead of schedule. You're keeping count better than us, Judge. But from the plaintiff's point of view, in our case, this trial is going to go a lot smoother if we have at least a half day and perhaps a day now and then during the week.
Okay, so why don't you get with Mr. Hunter and kind of get an idea as to what you want to do about next week? I feel, and I think this is kind of one of the things I said earlier, is when you have a really long trial, I mean, this is a marathon. It's not a sprint, and I want the lawyers to be able to do what they need to do outside of court, and I recognize that there's a lot of work that has to be done outside of court. So I am fine if we take 2 half days next week if you want to make it a full day on Friday, but it just seems like that's a lot of court days between now and then, when we've got a little bit of time that we could allow for a little bit of flexibility.
To be clear, I think Mr. Anderson was maybe talking about half a day this coming Friday, but that's not what you're talking about.
I was talking about next Friday, October 6th.
Yeah.
We prefer a full day off. That's better for us in terms of getting people in and having the time to coordinate the witnesses with the exhibits and figure out. And remember, we still have a bunch of exhibits we need to work through with the defense and perhaps with the court. So, extra time is always good. We'd prefer to have a half a day this week only for scheduling purposes, to allow us to figure out. I prefer not to put on Maya Kowalski this week. I think it would be better for our case if we did, but I think it's going to be a long process, and it's highly emotional. So I'm at a bit of a
what about this? And Mr. Hughes, I don't know if you've been able to get a hold of them, but what about assuming Dr. Chopra's plane arrives on time, that we do Dr. Chopra tomorrow, and then we can spend the afternoon hashing out whatever Mr. Altenberg and Mr. Elegant resolve tonight on this instruction. And so you would basically have a half day of testimony tomorrow, full day on Friday. And then we'll just...
I only stood, Your Honor, because we also have a physical therapist that has arranged her work schedule to be here first thing in the morning. She won't be a long witness, so that's just a heads up that we prefer her and then Dr. Chopra.
But she won't take long.
That's fine. And if we have to, finish him up an hour after lunch, I mean, the idea is to give you a little bit of time on Thursday. I mean, I'm just thinking that this might, because of the Dr. Kirkpatrick sickness, and I will tell you, and I'll tell us again, I think since there's a lot of people in this courtroom and a lot of people out and about, that if someone's sick and if we can rotate their time to a little bit, I think everyone would prefer a person who's not feeling well not come in.
Yes, Judge, we agree 100%.
The worst thing that's going to happen to us is if you all got sick or the jury got sick, then we're in serious time issues then.
Plaintiffs agree.
So just so I'm clear, because we're going back and forth, the plan for tomorrow is Chopra
And it's Rachel
DeYoung, the assistant? Okay. That works.
How long do you estimate that Chopra will take on the direct?
Obviously, depending on rulings, I would expect my direct to take an hour and a half, maybe a little less, and if there's a lot of discussion, it could take 2 hours. And then that would give you an hour and a half to cross.
Now, that would hopefully allow Mr. Elegant and I to address 39 and maybe a couple things that I don't think we're going to really reach today. I might take a couple of low-hanging fruits, and I would like to try to resolve what the instruction on intentional infliction of emotional distress for suicide looks like sooner than later, but I don't know that we're really going to have time to do that the way things are going this morning. So
That is a problem for tomorrow, but we'll solve it.
Well, I mean, I definitely want the instruction on false imprisonment and your issue. I really want it resolved tomorrow, so
Yep.
conceivably it will be given on Friday to the jury.
I think we can do that, Your Honor. I thought we were going to try to address the intentional infliction suicide instruction, and which I think we're close on with the court needing to make one call, and then the instruction on punitive damages. I'm ready to talk about those if there's time, but if there's not.
I've got the time. Do you all want to do it right now?
I'm happy to do those two. There, on a parent agency, there was a really minor issue as well. We might be able to get all that done.
So what number am I looking at? What din am I looking at this point?
May I please support? We've got witnesses to prep. May we leave this in the capable hands, Mr. Elegant?
It's fine with me.
Thank you. Full time, yeah.
Your Honor, 3425 is our memo on giving the standard punitive damage instruction. And it was in sort of further response to a more, what would you call it, multiple issue memo that the defense had filed about instructions. And I think the defense argument was, well, you didn't plead certain things, so you can't have an instruction, punitive damage instruction on that. But actually we did, because we point out the plaintiff's 8th amended complaint on paragraph 26.
Well, perhaps, Mr. Elegant, what will be helpful is if I hear what Mr. Altenburn's concern is, and then we'll get to your response.
Okay.
Is that doable? So, Mr. Altenburn, what DIN number do you want me to go to at this point?
Well, the actual instruction that we proposed is in 3397.
3397.
And I think the legal arguments are such that you probably don't need to look at that. And the punitive instruction there is going to be on about page. Well, it begins on page 15 of 49. It's a little off because it contemplated that Ms. Beatty would be a party at the time. But the critical thing is, and the distinction between us, is that they want to have the instruction based on the standard language coming out of section 768.72 with the three things that can make corporation liable under the statute. But in this case, and those things are that the corporation actively and knowingly participated in the conduct, or that officers, directors, or managers condoned the conduct, or that the employer or the corporation engaged in gross negligence and that contributed to the loss, or the three standards in the statute. When they filed a motion to amend for punitive damages, you entered an order saying that they were entitled to amend. We appealed that, that's been resolved, and that's not what I'm talking about here. But when they chose to amend their complaint, and this court entered an order, their chosen language was not the language of 768.72. Instead, in the complaint, in the first two counts, which were the only ones involved, for example, in one of the interlineations that sort of was amended into this in paragraph 74 is that the actions of All Children's Hospital were willful, wanton, malicious, and evidence to callous and intentional disregard for the life, health, and well-being of their patient, Maya Kowalski, which actions and or inactions as pled herein are substantially contributed to grievous physical, emotional, and psychological injury to Maya Kowalski. Now, when this case came up for trial a year ago, May, I pointed out then that the jury, I couldn't do the standard jury instructions based on the statute because that's not what they pled. They pled a different standard for that. And at that point in time, I'm sure they didn't want to amend because they were hoping to go to trial, but that did not happen. And since then, the complaint has been amended, I believe, twice. We're on the 8th amendment complaint, and they've never ever changed the language of punitive damages. So my position is that they have elected to have as the standard for punitive damages the language in their complaint, and that doesn't fit the statutory language at all. And if your honor disagrees with that and says we need to use the language from the statute instead, well, this is a claim for punitive damages is not a just add-on element of damage. It's a separate claim for punitive damages. It's supposed to have been pled under Rule 1.110B, I believe it is, so that it states a cause of action and it contains a short and plain statement of the ultimate facts showing that the pleader is entitled to that relief. And none of these elements were really pled in that action. The one I'm probably most concerned about is the subsection C of the statute, which is that the corporation engaged in conduct that constituted gross negligence that contributed to the loss. But there's not once that they even use the legal conclusion of gross negligence any place in this complaint. The counts we're involved with here are counts that the employee at least was engaged in intentional conduct. And so I don't want to have them trying to prove up some gross negligence claim that I've never had a pleading on at all. So I think that they have elected the language they put into their complaint, and that's the legal standard and the factual basis for their punitive damages claim. But if not, then at least when it comes time to evaluate this, it's not all three standards from the statute.
Mr. Elliott.
Okay, Your Honor, our response is that 3425, docket index number. And sort of preliminarily, of course, we have, unlike the suicide situation, we have a standard instruction, and the presumption is you give the standard instruction. Then we move on and we note a case that says, the complaint is a tentative outline of the position the pleader takes before his case is fully developed on the facts through discovery and evidence. Cite the case for that. Now, and then the statute itself, 768.72, draws a distinction between pleading and what the jury then considers. So those are two different things. But I think the main difference here, or main thing that's being overlooked, is that the plaintiff's Eighth Amendment complaint, which is 2816, if you look at page 6 of that, 26, when the plaintiffs are pleading for punitive damages, they say, quote, based on the actions and outcome described in this court's order granting leave to allege punitive damages, and the factual underpinnings are incorporated by a reference. Your Honor entered two orders. The longer one, there's one at 2034, and then there was one on clarification, rehearing, and so forth, reconsideration at 2103. And we've recited in the memo here, Your Honor goes to great length in there to describe some of the actions. On page 4, talking about that Beatty was acting. And I guess there's some similar names. There's a risk management committee and a risk management department. And as I understand it, I think while the risk management committee, which had a lawyer on it, apparently knew of some of this stuff, I guess they weren't the ones that were hands-on directing. The risk management department was. And Your Honor goes on in page 8 of that longer order, talking about what was done and what Beatty testified to. She's told to do this by the risk management department. Well, that's management. I mean, I understand there's been some discussion that, that department just had a bunch of retired nurses or something like that on it. It didn't have an officer on it. Well, Your Honor, if they take a committee or a department that's going to be in charge and dictating orders or providing instructions to people, and they want to staff it, I really don't care who they staff it with. They've given them authority to tell Beatty to do these things. And again, Your Honor recites some of those things in the order, and then those are incorporated by reference. So there is this greater detail that we're hearing should be there, is there. It's incorporated by reference from your order. So I think we are there. We should give the standard instruction. That's what's presumed correct. The requested instruction on, I guess what is this, page 16, just wants to talk about whether Beatty was a manager. I mean, that's where that's going. And that's not what this case is all about. So we think the standard instruction is warranted. We think it is pled enough, not that it needed to be pled in exact detail, because the pleading, again, is different from the issue the jury decides.
Anything further, Mr. Altenberg?
Your Honor, first of all, whether it's one risk group or another risk group is probably an issue of fact that we'll have to figure out down the road as the testimony comes out on that. But and Mr. Elliott is talking about the language of the wherefore clause in 75C on page 26 of the complaint. I'm relying on my memory, but I'm pretty certain that the language for punitive damages based on actions and outcomes described in this court's order granting leave to allege punitive damages was actually stricken from this complaint by you at some point in time because you didn't want to have them incorporating your order into their pleading. So I don't know that that's actually even there. But one way or the other, the punitive damage instruction statute, rather, in subsection 1 talks about the process of getting the right to amend, but it doesn't contain language about what you put in or choose to put in your amendment. And what they chose to put in was simply that these legal conclusions about willful wanton and the like, rather than telling me that someone was grossly negligent or the like. So I don't believe that they're entitled to the benefit of a statute when they didn't plead the ultimate, they didn't plead that as a legal conclusion at all in their complaint, and they didn't lay out the facts other than perhaps some facts that may go to one prong of this.
Having reviewed my orders on allowing punitive damages and then the order on the reconsideration that Jay Hatch filed, I am comfortable that the gross negligence is included, and therefore that variant would also be subject to being instructed upon, obviously depending on what actually comes in.
Sure.
So I guess what I'm ruling, Mr. Altenburn, is I disagree with your position that the pleadings preclude that variant of punitive damages for just those two claims.
And therefore, you want the final instructions to be based on the statutory language rather than on the pleadings.
Exactly. Now, it looks like you have other items in here. I don't know if those are disagreed to or not.
As to punitive damages, I suspect that Mr. Elegant and I will probably end up, that this was the big fight. So I think we can probably work on the standards at that point in time. Because you just told me you want the gross negligence standard in there, and one of the concerns was which elements. So at least for purposes of now, we'll probably put all three elements of the statute in pursuant to your order.
Because I think in my order I indicated that the proffer was sufficient for any of the three variants.
I think you did, yes. My position was that after you told them they had the opportunity to plead that, they didn't.
I understand.
Okay. Thank you, Your Honor. I think maybe next is I think it would be useful to the parties to have a determination on I guess we'll call it the suicide or intentional infliction standard. We're proposing language, and it is, I'm looking for in our DIN 3401, we have an Exhibit D. 3401. And let me know. I'll wait for you to get there. And
I'm at 3401. Just Exhibit D, you said?
This is Exhibit D, which will be a ways down because I think Exhibit B was the instructions we were working on with some comments. But Exhibit D is just one page. And it's, I think Mr. Altenburn had prepared an instruction that parts of we were okay with, but then his instruction, I think, referred to a California case and that the plaintiff or the deceased had to be suffering from a mental illness or something along those lines. We found two Florida cases that talk about, if there's a quote, when you get to 3401D, you'll see there are quotes from both cases. 3401 Exhibit D. There are quotes from both cases. There's a Florida First District case.
Just so I'm clear, is that the Nelson versus Seaboard?
Yes, Your Honor, it is.
On there.
That quote that the person being sued had to have driven the deceased beyond the point where she could rationally decide against killing herself, and then that case is then cited in a more recent federal case, and they agree with that, and then they refer to such severe stress and emotional upheaval that she killed herself in response to an uncontrollable impulse. So the Florida case law, our position does not require the person have a mental illness. You can have, and if one just sort of steps back, I think, and thinks about it from a common sense point of view, not everybody who commits suicide has a mental illness. I mean, some people do it, for other reasons that, they feel overwhelmed for whatever. It could be a variety of things. It could be financial. It could be emotional. It could be family. And in this case, it was family. And those people don't necessarily have a what is it, the DSM or whatever, mental illness. And so we would argue, and there is, I think we agree, both sides agree there's no standard instruction on this, but that we think that when it comes down to describing this part of it, it should be the Florida law and not the California law.
Mr. Altenberg.
Your Honor, I filed a fairly extensive memo on this, and I apologize on my own version of this. I don't have the DIN number, but it was filed on September 6th of this month at 9:53 a.m. The request is
That's 10-3346.
3346. And basically, Mr. Ellicott is right that there isn't, not only is there no standard instruction on this, but to, I think, the best of all of our research, none of us have found a case that went to trial on this issue any place in the United States. And so the case law that he's relying upon, and the case law for that matter that I've given to the court from other states, is cases that are primarily discussing, well, did it pass a motion to dismiss, or did it pass a motion for summary judgment, or not? In many of the cases, it did not pass those things. And so this case law is, I think, helpful to the court, but the notion that anyone in the United States of America has something that they've settled on as the instruction to give to a jury in this case just isn't there. So this is probably the hardest and biggest legal issue for both sides of this case, and the most likely issue to be one that we would raise on appeal one way or the other.
And is your proposed instruction the one that's at the bottom of page 2?
Bottom of page 2.
Of your memo?
No. Actually, the memo goes forward and gives you 3 instructions at the end, because I believe that the instruction should be limited. If I can kind of just go through this very quickly.
Yes, sir.
Everybody here and in all the other cases around the country agree that there's something more you need to say to establish a claim for intentional infliction of emotional distress that results in suicide, because of the strong common law presumption that suicide is an intervening break in the chain of causation. Those cases clearly, as a result, are focused on the concept of foreseeability. Some of the case law is discussing it in the sense of, well, what's sort of the duty you owe to another person here that would be such that it would be foreseeable that suicide could occur. And some cases have focused on, well, does the conduct cause the suicide as a proximate cause concept, not of the damages, because once the person is dead, the wrongful death damages are a fairly easy proximate cause issue. So my position on this is, if you look at Tate, which is the case that they relied on from California, is one of the, if not the earliest case, one of the earliest cases from about 1960. The whole focus there is on this being a tort of intent, and that it has to be extreme conduct. And so my first preference is one that is, and I've argued this to you before in motion to dismiss, and you did not really accept this, so I'm not expecting that you're going to say, yes, I'm right. But because of the nature of this tort, and especially in this attenuated situation where the tort is somewhat difficult to explain in terms of outrage just as a basic tort, keeping in mind that we have no right to comparative negligence, we have no right to contribution from anyone else. This tort puts us, because it's an intentional tort, on for the ride for the whole 9 yards of damages, that the standard for this should be one that requires that the person committing the extreme and outrageous conduct must have actually intended to cause severe emotional injury to the plaintiff for the purpose of causing the plaintiff to commit suicide. The situation, and I've admitted this before, that if someone comes and says, you know, your only real solution here, sir, is the only option you've got left is suicide, and you know, here's a gun to do it with, or assists them, pushes them to get them very upset to have them commit suicide, I think that states a cause of action. Now, that factually is not what we have here, but if I'm arguing to a court that can set, you know, a binding rule for the state of Florida, I think in light of the strong standards in the case law we have on negligent infliction, that where we stand in the state right now is that it can't be reckless conduct that causes this. It has to be intentional. I intend to create an emotional distress in you, and it has to be stress that was done actually because my intent is to have you commit suicide. So that's the first instruction that I have requested here. If you want me to stop and we can go to the second one after that, that's fine.
Well, I will tell you, I'm not going to rule from the bench.
Yes.
But
okay.
Mr. Elliott, did you want to say anything there, or do you want Mr. Altenburn to keep going?
I think he can keep. I think I heard him say you didn't buy that the first time, so I'm not going to say anything to try to help him out. No offense.
The second part of this, and again, it's laid out rather carefully in the memorandum, is that if we get to the issue of recklessness, then recklessness is a standard that needs to be more specific in these. And because a lay sense of what is reckless and what the law has as the standard of reckless are really pretty different concepts at this point in time. And there is actually a standard on recklessness that exists in the restatement that has been cited in Florida. And in my memorandum, it's at the bottom of page 7. The problem with it is that even I, reading it with the text in front of me, can't understand it. It's very complicated. And so I don't even try to read it. But what I have done is try to turn it into something closer to plain English. And that instruction is that in order for All Children's Hospital to have acted with reckless disregard of a high probability of causing severe emotional distress to Beata Kowalski, resulting in suicide, A, one or more of its employees must have intentionally performed acts or made statements that when that person knew or had reason to know of facts which would lead a reasonable person to realize that his or her act created an unreasonable risk of suicide by Beata Kowalski. B, the act or statement must be more than an act of negligence. It must create a substantially higher risk of suicide than the risk that would be created by a negligent person acting unreasonably. And so I have, if you decide that it can be either intentional or reckless, I'm asked for the instruction to incorporate that concept. And finally, really on either of these approaches, because I've done it in all of the instructions at the end. There's 3 that I'm proposing at the end. The Nelson case that they have relied upon, again, was not a jury instruction, and even more importantly, it was in the context of FELA, which has the federal standard for that, which is akin to workers' compensation, is more like the slightest negligence is all it takes to be liable under FELA. So the Nelson case is not a very strong foundation for us to try to jump from a workers' comp standard to something as high as the intentional infliction of emotional distress standard. But if we do that, I mean, what I've shown you in the memo is the concept of whether it's an irresistible or or a uncontrollable impulse, that does show up around the country. And I think they prefer uncontrollable. I don't really think I care one way or the other whether it's irresistible or uncontrollable. But then the difficulty is, how do you explain what an uncontrollable impulse is? And the case law on that comes more from the state of Mississippi than from other places. And it tries to draw some fairly fine distinctions between mental conditions and mental illness. And that if it causes a mental illness rather than a mental condition, that may be enough. And they use that language to basically explain that it's an uncontrollable impulse. So in one of those cases, let's see if I can find the language here. The court actually goes to the testimony and says that the plaintiff's psychiatrist, Dr. Barnes, stated that if you asked Schomburger, the plaintiff, what he was going to do before he committed suicide, he would have said he was going to kill himself, and such acts were voluntary and with the knowledge of the consequences of his act. And as a result of that, they found that it did not pass a test where it would be sufficient to be a claim for intentional infliction. And the language that I have sorted through on this, that I think comes fairly close to the other cases that have this irresistible or uncontrollable impulse, would be that she did not have the ability to know what she was doing. And so the instruction that I have given at the end, let me read the language here, is that in order for All Children's Hospital to have acted with reckless disregard of a high probability of causing severe emotional distress to Beata Kowalski, resulting in suicide, I'm reading the wrong one. For extreme and outrageous conduct to be a legal cause of suicide, the extreme conduct must have caused a mental illness that resulted in an uncontrollable impulse to commit suicide. The uncontrollable impulse must be sufficient that it can be said that the plaintiff did not have the ability to know what she was doing so that she could not stop herself from committing suicide. And I believe that is better than the language that they have suggested, which is in a paragraph that actually begins in other words. It was just kind of a colloquial restatement of what Nelson was holding would be the cause of action in that. So those are the three positions that I'm taking on the jury instructions.
Mr. Elegant.
Yes, Chris, could you tell me what, I think you didn't have the docket and index number, but what date that was? I think I missed that.
It's 3346, DIN 3346.
Oh, okay, that's bad. Okay, let me write that down. 3346. Well, rather than get into the detail on it for the moment, here, sort of working backwards, but could not stop herself. The problem with that is, Your Honor, that we don't think that reflects all the circumstances, and particularly the circumstances in this case. Here, and again, I admit to being the least knowledgeable of this, but my impression is that the plaintiff's position is going to be, she concluded this was the only way. This was the only way her daughter was going to get released from what she thought was an untenable situation. And that's, is that uncontrolled, is that couldn't stop herself? That may be, hey, look, I mean, it would be like a person that had extreme debts and he's worried about taking his family under. He says, but I've got $1 million worth of life insurance and the suicide exclusion is past that. I'm gonna make my family rich. I mean, that's not couldn't stop yourself. That's in a sense a logical, outcome. So that's a problem I have. Second, the Nelson case is a comp case, but it's then cited by the federal court, Middle District in 2008 in a state of Duckett versus CNN. I think that court thought it had broader application. I think that if Your Honor could give us some guidance, and I understand not wanting to rule from the bench on this, because I would agree, it's an involved issue. I think if you could give us some guidance and say, and not necessarily at the moment, but say, look, I'm not going to require a finding of that she was mentally ill, or I am going to find it. I am going to require that. And again, our position is Florida law doesn't require it. But I think if you told us that, you could rule on that narrow point. I would be hopeful that Mr. Altman and I could work out some language and at least give you an instruction that if it wasn't agreed to, it would have, okay, here's what we want, here's what they want. And then you could make those choices.
Let me ask you this, Mr. Elegant. So you're suggesting that the law should recognize or does recognize a person who rationally decides to end their own life as able to, or her estate to collect for a rational decision to die by suicide?
If to collect from someone that drove them to it, to make that to where they said, this is my only chance. Now, you and I might not say that's rational, but that person might have thought it was. In other words, getting back to, and I guess one other point, I don't think, and I think this goes to your question, I don't think the defendant has to have intended that the person commit suicide. I think I heard that as one of the arguments, and that may be the one that you didn't agree with. But anyway, because you could do something that's and the idea that the person may commit suicide never enters your mind, never enters the defendant's mind, but they still do these things, and that's a foreseeable outcome. So, I don't think I think we would all, I would hope we would all agree that there are better alternatives to suicide, and people ought not to do it. And that, but I don't think and again, it says had driven the deceased beyond the point where she could rationally decide against killing herself. So I'm not saying it has to be a rational decision. I'm saying I see people could get there without being mentally ill. Okay. In the Florida one does not say, I don't mean to say that says it's a rational decision. I was giving an example where I think you could say some people could get to that conclusion. Now if it's somebody that's been, to use my earlier example, driven up their own debts and they're, and now they feel at their wits' end, they've done it to themselves. But, if they were being hounded by somebody, saying you got to make this right, I'm going to put you in jail, I'm coming after your family if you don't do this, then, have they been pushed to it? Is it still a rational decision? Maybe not, but.
Let me ask you this, Mr. Elegant, and
Yeah.
I don't know the answer to this, and I have seen press reports about cases involving cyberbullying and a person taking their life. I seem to think that those were in criminal context, maybe not in the civil context. But isn't that really what you're kind of talking about, that a person gets hounded so much in a la the cyberbullying that causes a person to take their life? And then I don't recall in those press reports any sort of necessary finding of the decedent having a mental illness.
Exactly. And yes, I think, Your Honor, that's one of the places we look for research on this, and I don't think we found a civil one either. I think there is a statute that addresses cyberbullying, so that's a little different. So I didn't think we would really analogize to that because we don't have a statute here. But yes, I think that is comparable. And if and again, did the bully intend a suicide? Probably not. They probably were just thought they were having fun and they were, picking on this poor person. But, so I think that's all in the same genre, Your Honor. And I just don't think I don't think we have to have a mental illness is our point. And I think if we have a ruling on that, I think if we couldn't work out all the language, I think we could give you an instruction like we did a little bit earlier on the pre-opening ones that said, well, plaintiff wants this, defense wants this.
Mr. Altman, any further comments?
Yeah, two or three things. First, very quickly, the federal case he cited that followed Nelson took me a while to find it. It's not actually in Westlaw, but it was an order entered by Judge Terrell Hodges on a 12B6 motion to dismiss, emphasizing, by the way, that it was on a motion to dismiss and not a motion for summary judgment.
So that one is not indexed in Westlaw
it's
at all?
in Lexis if you have access to it, but I didn't have access to Lexis.
I don't think I have
But I could look
Lexis.
it up on Google, and I did find it. But the facts,
I'm sorry, I'll be glad to send it around. Sorry.
the
Yeah,
facts of that case are-
could you send it to my judicial assistant? But there's enough Judge Hodges clerks running around that I'm sure we could.
It is on the internet because I did find it. What I can tell you about it is it's a case where a woman whose 2-year-old child was missing got talked into giving an interview to someone named Nancy Grace, who apparently was one of the people that puts things exciting on CNN News. And the allegations were that she ambushed her in the interview with false statements while she has a child that she's trying to find at that moment in time. And CNN announced to her they were going to broadcast it the next day. And so hours before that broadcast, she committed suicide. And Judge Hodges let that stand on a motion to dismiss. Well, that's very much one-on-one bullying with a person that you're seeing or hearing. I think it was a telephone.
So Judge Hodges allowed that case to proceed?
To proceed on a motion to dismiss. And again, emphasizing he wasn't ruling on a summary judgment in the order I read. And I can tell you from a bullying standpoint, and I have cited the case, there is a case from Illinois, Hankins versus Alpha Kappa, which is at 447 Fed Sup 3rd, 672, Northern District of Illinois, 2020, where another case survived a motion to dismiss, but that was a girl actually living in a sorority house, and the sorority sisters were hazing her in a very extreme fashion, and they knew and could see that she was emotionally upset, and she committed suicide. My point, and by the way, I don't know that it ever gets prosecuted actually, but assisting suicide is a form of culpable negligent manslaughter in the state of Florida. I'm on that committee. We've never done a jury instruction on assisting suicide culpable negligence. The instruction just says, if you need one, you're going to have to write it yourself. So I don't know how we jump exactly from the criminal law to this, but I understand there's a bit of a parallel. But all of those things have been where there was a mens rea, where people were intending to do something, or at least it arose to the extreme level of a culpable negligence for purposes of manslaughter. And that's really not what we have here. So I don't know that we can use that standard. And so, as Mr. Ellicott has explained, this woman decided to commit suicide as the only way to get her child released. She was in a situation where the trial judge wanted to have the dependency hearing a month later, and she didn't want to wait to win a dependency hearing, which they claimed she could have won if it had taken place. It never took place. But, the decision she made was actually, I guess, effective, because the child was released by the court almost as soon as she committed suicide. It is, in my mind, an irrational decision, but it was something that she thought through in some level. And so I'm just saying that equating this to bullying, there's got to be some language that is more refined than that. And I think that if you reject my first instruction, that one of the second or the third come very close to the mark.
What I will promise is I will try to have some sort of thoughts to you by Monday as to where I am with this. I don't know how fleshed out an instruction will be, but at least
I'll try to narrow the playing field such that we can proceed further.
Because and that would be very helpful, because that way we know what is relevant and irrelevant to some degree going down the road.
Well, I appreciate this conversation, because this has also been helpful for me to help frame where and how I'm going to be looking at this.
Your Honor, it's about almost 11:30, and you had indicated that you didn't mind if we ended early. So although there's other things we could go on to, it may be a good time to stop this. I do know we had at least one or two trial concerns that we wanted to bring up, but I guess Greg's not here.
Without
so
Mr. Anderson
Mr.
being
Anderson's
here.
not here. We shouldn't do that.
Yeah, that was my thought.
Well, is it something that you can at least let Mr. Elegant know that they can relay?
Sure.
So that you can at least be thinking about it?
Yeah, sure, Your Honor. There's it's back to a skilled witness issue. Dr. Napolitano, for example, he was here as a corporate representative. He gave a deposition, and he was a member of the risk management committee. His deposition was narrowly tailored and ordered by this court only to address risk management committee issues. Plaintiffs want to play his deposition. We believe he's not a skilled witness. He may be an MD, but he didn't have any clinical involvement with Maya Kowalski. He's actually a neonatologist. His role and function was simply to talk about risk management committee issues, and for that reason, we believe that he's not a skilled witness. He should come live. And I would point, Your Honor, to Your Honor's previous order at DIN 3361, where we addressed a similar issue, where we had a licensed mental health counselor and an RN, but both of those weren't functioning as RNs, or they weren't functioning as a licensed mental health counselor. We believe Dr. Napolitano fits within that. He's ready, willing, and able to come testify. And this court's also indicated that we didn't want this trial to be hitting play and playing depositions a lot, so we think that Dr. Napolitano, whenever they decide to call him, should be here live and not played for the same reasons and logic set forth in DIN 3361.
So Mr. Elegant can relay that concern, and we can, if y'all can't work it out amongst yourselves, then I'm sure in the near future we can make a ruling on that.
Yeah, and there's also an attorney, Jackie Crane, that falls into that role, but we can discuss those issues later.
Anything else that you all want and or need from me at this time?
Mr. Elegant's on Zoom in front of me right now. Can I ask him whether there's a good time I can set a Zoom for this afternoon for us to meet?
Yes, I have something at 1, but I'm sure, let's put it the way, if it's not done by 2, I'm going to leave anyways.
All right.
Judge, and Chris, one thing, just sort of an observation I would make on the intentional infliction of suicide is that, and I agree this is a complicated issue or challenging issue, whatever. I think one thing we can all keep in mind maybe as we head toward the end of the trial is there may be a way to deal with some of these things with a special verdict form, and not necessarily just that instruction, but some of the other stuff. I mean, I appreciate the verdict form is probably going to be a significant anyway, but.
Well, let me reiterate my comment. I don't even remember when I made it, but to the extent I can have interrogatories that will prevent us from having to try an issue again, even if, we might not agree that something needs to be found, getting the interrogatory response is going to be helpful. So to the extent we can logically make that happen, I probably want to craft them to allow that to happen.
You did make that comment last week, and hopefully Mr. Elegant and I, who worked with or against one another for a long, long time, can help you with that.
And I appreciate both of you. I know it's not easy in this case, and I appreciate your efforts.
Thanks, John.
Anything else?
No, Your Honor.
That's good.
We'll be in recess. Have a good afternoon.
Thank you.